I am State Representative Toni Rose, and I represent House District 110. I first would like to thank each of you for being here this morning as I introduce House Bill 3080, which was filed this morning and will exempt persons with severe mental illness from the death penalty. Joining me are colleagues from both the mental health and religious communities, or faith communities. So we have with us today Greg Hanch with the National Alliance of Mental Illness Texas, Yanis Banks with the NAACP, Jill Switzer with Mental Health America of Texas, Dr. Brenda Richardson Row with Concord Baptist Church in Dallas. We have Jennifer Allman with the Texas Catholic Conference, Ms. Tricia Forbes with the Texas Fair Defense Project. We have Dr. Kimberly Harrison, who is a mental health professional, Ms. Janie Metzinger with Mental Health America Dallas, excuse me. We also have Ms. Latasha Taylor with Grassroots Leadership and Ms. B. Moorhead with Texas Impact. Protections that currently exist for an individual living with severe mental illness do not include an exemption from execution. Texas criminal procedures focus on a defendant's mental state at the time of a trial or execution and do not address the issue of reduced culpability and a person's ability to understand if he or she committed was morally wrong. The result is a system that fails to address the relationship between a defendant with mental illnesses, functional impairment, and his or her ability to understand the implications of their conduct. House Bill 3080 solves two problems with the treatment of defendants and prisoners with mental illness. First, it places an emphasis on the defendant's mental state at the time of the offense. Under this bill, an individual who has a verified diagnosis of severe mental illness with active symptoms at the time of the offense cannot be sentenced to death. However, that person will stand trial for the alleged offense and serve a sentence of life in prison without parole if convicted of a capital offense. Second, it makes a determination of a defendant's eligibility for a death sentence in the front end of the proceedings. The Eighth Amendment prohibits the execution of individuals who is mentally incompetent. However, the assessment as to whether the defendant is or is not competent to be executed occurs close to the execution date. After the state has paid for a death penalty trial, incarcerating the defendant on death row, and years of appeals. Together, these costs are estimated to be as high as $2.5 million per case. House Bill 3080 streamlines the determination process and returns a cost savings to the state and county taxpayers. This bill is also consistent with constitutional bars in executing a person with intellectual disabilities and juvenile defendants. The proposed exemption captures a greater percentage of defendants who are affected by mental illness. However, it also does not prevent individuals from being held accountable for their actions. Individuals who would qualify will serve a term of life without parole if convicted of a capital murder. So I have a few takeaways that I would really like for you all to leave here with today. First, the bill will not allow offender to walk free. This simply creates a procedure to appropriately handle cases of individuals with severe mental illness. And it also applies on a case-by-case basis. A judge or a panel of citizens will consider all of the evidence to determine whether an individual has a severe mental illness or active symptoms at the time of the offense. This bill will significantly reduce the chances of executing innocent people. Individuals with a mental health condition are more vulnerable to police pressures. They may have an impaired ability to participate in their defense and are more susceptible to being wrongfully accused or convicted of a crime. Also, I want you to make sure that you note that it only applies to severe mental illness, not all mental illnesses. This bill applies to individuals with a medical diagnosis of schizophrenia, schizoaffective disorder, paranoid or other psychotic disorders, bipolar disorder, obsessive compulsive disorder, and depression. Again, this bill will require proof. This proposal would add an exemption only for individuals who can prove he or she had a qualifying medical diagnosis or documented symptoms of a severe mental illness before they committed the crime. One of the things we have to note that these illnesses are not a choice. These illnesses often cause the behavior of those affected to be involuntary. Severe mental illness can cripple an individual and significantly impair one's ability to make decisions, make decisions and control their impulses and understand the consequences of their actions. Severe mental illness can also impair a person's judgment, impulse control, and decision-making skills. Let's also note, this bill will save taxpayers money. This exemption would eliminate expensive court proceedings that are specific to death penalty cases, such as lengthy jury selections, a second penalty trial, lengthy pretrial investigations, and the entire appeals process. Now, at this time, I would like to allow a few remarks from some of the supporters of House Bill 3080 to give some remarks, and they will introduce themselves as they come to the microphone.
Good morning, everyone. My name is Greg Hanch. I work as Public Policy Director for the Texas affiliate of the National Alliance on Mental Illness, NAMI Texas. First, I'd like to thank Representative Rose for filing House Bill 3080. Also, I'd like to thank you all for being in the room today. Let's be clear on a few important facts from the start. Severe mental illness is not a weakness. It is not a character flaw. Severe mental illness alone does not predispose a person to violent behavior. Treatment works, contact with the criminal justice system can be avoided, and recovery is possible. And executing individuals with severe mental illness at the time of their crime is not justifiable, is not an effective crime deterrent, and is not economically sensible. NAMI Texas has 27 affiliates throughout the state and approximately 2,000 members made up of mental health consumers, family members, friends, and professionals. Our purpose is to help improve the quality of life for people affected by mental illness. In 2006, the American Bar Association, the American Psychiatric Association, the American Psychological Association, and the National Alliance on Mental Illness all endorsed a resolution calling on states that impose capital punishment not to execute or sentence to death people with severe mental illness whose capacity was significantly impaired due to the symptoms of their illness at the time of their offense. It was quite possibly the first time that all four of these organizations agreed on a singular policy position. In August of 2016, the American Bar Association reaffirmed this position when adopting its criminal justice standards on mental health. There is a growing scientific consensus that severe mental illness can significantly impair one's ability to make rational decisions, understand the consequences of one's actions, and control one's impulses. The Supreme Court outlawed the death penalty for persons with intellectual disabilities and juveniles because medical research shows those individuals do not have the same mental capacity as fully functioning adults. People experiencing symptoms of severe mental illness are clearly deserving of similar protection. And yet there is no categorical protection from the death penalty for individuals who had a severe mental illness at the time of their offense. As Representative Rose mentioned, House Bill 3080 would apply only to a narrow set of illnesses, would apply on a case-by-case basis, would require proof, would apply only, again, to a narrow set of illnesses, and would allow our government to hold individuals accountable for their crimes. As our state's leadership considers this bill, I invite them to consider what is fair, what is humane, and what makes fiscal sense. When individuals with severe mental illness face capital punishment, a process unfolds that frequently extends an already emotional, difficult ordeal for all parties, often resulting in years of litigation and occurring at a high financial cost to taxpayers. We know of examples of people who ended up on death row despite being profoundly ill for years leading up to their crime. Some are eventually executed. Others are ping-ponged back and forth in the appeals process for years, even decades, while the taxpayer foots the bill. Not to mention, these individuals are more likely to give false confessions and to be wrongfully convicted. Make no mistake about it. Attempting to execute an individual who had severe mental illness at the time of their offense is a broken aspect of our criminal justice system. This is also a failure to protect individuals with severe mental illness from a punishment that, quite frankly, they didn't deserve and that we can't justify. This bill is an opportunity for us to close this clear, costly loophole in protection from capital punishment. So thank you, Representative Rose, for filing House Bill 3080. NAMI Texas supports this proposal and requests that the legislature move swiftly to pass it. Texas has an opportunity here to stand up for what is right for our state and for individuals with severe mental illness. Individuals with severe mental illness present at the time of their offense should not be subject to capital punishment. Thank you so much. I'd be happy to answer any questions.
Good morning. My name is Giannis Banks, Legislative Liaison with the Texas NAACP, and we're proud that Representative Rose has filed this bill. And I think this bill was important. In October, the Chief Justice Heck came to address our state convention and talked about his legislative priorities for his upcoming sessions. And one of the things he focused on to us was that he would like to see changes in mental health laws for the 2017 legislative session that would permit a more comprehensive, effective, and sensitive treatment of mental health issues in all courts, including criminal, civil, and probate courts. And I think this was fall in line with what he was asking for, what he talked to us about. And if I remember correctly, I believe he even addressed some of this during his State of Judiciary address. And so we're glad to see that she's filed this bill that's going to reduce maybe having some innocent people executed. We know that mental health is a serious issue in this country. It impacts all communities, whether you're rich or poor, black, white, brown, or otherwise. It sees no color, it sees no bounds. And this is something that we need to make sure that when we're doing our justice, because this bill is about justice, that justice is fair and that we understand what they are going through. It's a very sensitive topic for a lot of people. And we know that when dealing with criminal defendants or court-appointed attorneys, they may not always be aware of what the people are going through because they don't always have the funds or understanding of the people they're dealing with because they have such a large load. They don't get to know their client all that well, all too well. And so this gives them the opportunity to have that front end, as she talked about, defense than trying to go through the appeal process, which can be costly, which can be lengthy, and the person themselves may not be able to participate fully in due to their condition or lack of medications that they're having. So we're glad that she's filed this bill. We think it's going to go a long way for justice. It's going to benefit all of Texas, not just any particular groups. And that's very important, that when you're looking at justice, you're looking at safety, and you're looking at what's fair, that people have a chance to be fair. And once again, like you said, they will face life without parole. So there's still justice being served for the families, and it's a fair bill. And we definitely support her and thank her for filing this bill.
Good morning. I'm Dr. Brenda Richardson Row, and I'm the Minister of Counseling at the Concord Church, where Reverend Brian L. Carter is the senior pastor, and I'm the director of the Harmony Counseling Center. We have gained significantly greater understanding of mental illness and its effects in recent years. This increased knowledge has led to an increasing concern regarding the treatment and processing of severely mentally ill individuals in our criminal justice system. The American Psychiatric Association defines mental illness as a syndrome characterized by clinically significant disturbances in an individual's cognition, emotional regulation, or behavior that reflects a dysfunction in the psychological, biological, or developmental process underlying mental functioning, usually associated with significant distress in social, occupational, and other important activities. When we consider mental diagnoses that are severe, the scope even narrows and would include diagnoses such as schizophrenia, schizoaffective disorder, bipolar, major depressive disorder, and post-traumatic stress disorder, to name a few. These diagnoses are persistent, usually impacting the individual throughout their lifespan, and causes severe impairment in all levels of function. Their illness can impair the ability to interpret reality accurately, to comprehend fully the consequences of their actions, and to control their actions. The renderance of a death penalty does not serve as an adequate legal outcome when considering the mental inabilities of the severely mentally ill. Many times, these individuals have also been impacted by other social injustice such as limited or no insurance, limited access to mental health facilities, limited or no access to needed medication, and the list goes on. The Lord tells us that He is close to the brokenhearted. And paraphrasing, He is also broken to those available that have broken spirits and who have broken minds. He saves those who are broken and who are crushed. I plead with you to provide a just yet accountable outcome for individuals with severe mental illness who commit capital issues that align with this great state of Texas's motto, friendship. Please exempt these individuals from the death penalty and show them the love of friendship, the love of friendship that is born for a time of adversity, a time such as now. Be blessed.
Good morning. I'm Janie Metzinger. I'm the Public Policy Director for Mental Health America of Greater Dallas. And I want to thank Representative Rose for filing this bill. You know, society has the right to protect itself and to do justice. And I think there's two ways that this bill does that. First of all, as an earlier speaker, as Greg said, people with mental illnesses are not necessarily violent, that they're much more likely to be the victim of violence rather than the perpetrator of violence. But when the situation is such that we're discussing today, society does have a right to do justice and to protect itself from further harm. But it also has the responsibility to do justice and prevent that harm in the first place by providing adequate mental health and mental health care, particularly for people who have these severe and persistent mental illnesses, in an effort to not only prevent tragedies such as a murder or a capital offense, but also to prevent the tragedy of a wasted life. And so we thank Representative Rose for being such a strong advocate for mental health care in our mental health system and for people with mental illnesses, as this bill exemplifies. Thank you.
All right. Well, again, I would like to just thank each of you for being here with us this morning as I lay out 3080 file it today. Well, I've already filed it. So, but I would just like to ask if anyone have any questions at this time. We would be more than happy to answer any. Hopefully, we covered it well enough for you. May not have any questions, but should you have any, we'll be more than happy to answer any questions.
So how would this kind of affect cases that, obviously this is sentencing at the trial level, so what about cases like stop committing, which you would then use this as an argument in appeals? So people who've already been sentenced to death who have severe mental illness.
Are you asking, is it going to be like retroactive to where cases that have already?
Yeah, and if appellate lawyers will be able to use this to claim it like now. So yeah, kind of retroactive, but also just in the appellate law, if that would be brought up.
At this time, we haven't. Greg, could you come answer that question for me? Because we were. Oh, it's silent.
It
That's
doesn't
what I
say.
thought, and I just wanted to make that, and that's what I thought, but I didn't want to. Greg has really been helping me with this champion this legislation, and I thought that's what we said it was silent and we didn't address it, but I wanted to just have backup for that. So thank you, Greg. So we covered it that well. That's awesome. So again, I would like to thank the mental health advocates for being here in the faith community, for joining me in this important legislation. I really think it's would be very transformational for our state, and I just look forward to gaining additional support as we continue to get the word out about it. So thank you.